If I can just welcome you then, Sally, now we're recording. Welcome to the Neurodisability Special Interest Group for the Global Law Enforcement and Public Health Association. We're delighted today to welcome Sally Kedge, who's going to talk to us about addressing language and communication accessibility in justice contexts in New Zealand. Thanks, Sally, over to you.
Thank you. And I wanted to start by saying tēnā koutou katoa, kia ora koutou, which is I'm welcoming all of you in Te Reo Māori to this presentation, and I'm really grateful for the opportunity. So hopefully what I've prepared is going to be a good fit for the audience. I wasn't quite sure who was going to be here and what you would already know about the work that speech language therapists and communication assistants might be doing. But anyway, we'll just see how we go, and hopefully there's time for some discussion at the end. So I'm usually working in the justice system, and I think one of the things that a lot of the people that I'm working with are often wondering, even if they don't say it out loud, is what is all of this about? Who the hell are you? And how long is this going to go on for? So I thought I'd just make sure I'm really clear about that up front, what I'm going to be talking about and the other questions. So I want to talk about the Aotearoa New Zealand context, and Aotearoa is the Māori name for New Zealand, because we are working here, and that's a really important part of what we're doing. And this is what I'm trying to address today. How do we try and tackle all the challenges that come from the complex language and communication involved across the whole justice system for children and adults, whatever participation their role is. And then I'm going to bring in some examples from the work that we do in our team. So I'm going to try and talk 40 minutes. I've packed way too much material in, as I usually do, and I'll probably go way too fast. And I think I'm going to be talking, though, to an audience who can cope with that. You're good at listening, you're good at words. I think that's going to be fine, but I'm really aware that isn't always the case for the people that I'm working with, so I don't usually go at this kind of like as I go through, and I will explain who I am as I go as well. And I guess I like a timeline. We often draw timelines in some of the work that we do, and I guess I wanted to say up front, it's a bit of an audacious title I've given this. We're not addressing language and communication across the whole justice system yet. There's a lot to do, and it feels like we're barely touching the sides, but I feel like there's a little bit that we've managed to start, and I'm going to explain what those are and also where the gaps are as well. So I think the first thing I want to say is I'm very privileged to be working with real people, and it is their lives and expertise. And that is a really important thing to keep in mind, I think, when we're doing work in these spaces. And there's been some work done in New Zealand by a researcher called Dr. Kelly Howard, and she was exploring what do people who receive communication assistance services, particularly in the youth justice system, think about that. And this member of someone's family in whānau, she said this: I just needed my son to understand everything. This was his life. And I think that's really important to keep in mind here. These are people's lives, his life, her life, and all the other people's lives that are touched by involvement in the justice system. And I'm in a situation where I'm often working across the justice system in many different spaces. But I think this quote that this woman said here, the seriousness of the charges was my concern. And I just needed my son to understand everything that was going on, what the lawyers were talking about, what the lawyers and judges were talking about, so that he understood every part of what was happening through that whole process. Because this was his life, a big chunk of his life. And I think that's been really important to understand in the work that we do. The consequences can be profound when people do not understand, and the risk of miscarriage of justice and what that can hold for any of the participants is really enormous. And some of the other expertise that's come from people who have told us what it's like to have to communicate in the justice system have been things like this. This came from a young man in a youth justice residence and in a research project I was involved in. And he gave his views because he knew that we were going to be passing those on to judges and police and social workers and lawyers. And I think his experience characterizes the many that I've heard from other people about not knowing the words to say, it being hard, and then everything just basically going to shit when it became too hard. And then that led to him becoming anxious and losing the plot, really. And those kinds of experiences had been his experiences in court and in family group conferences, which are an important, also talk heavy space that goes on in our justice system in New Zealand. There's more expertise here from another woman who was talking about her experiences of the language and communication in the care and protection system. And she said, I didn't understand all the legal or jargon talks and expectations that they wanted. I didn't understand anything. I just wanted to know what the hell was a 333? What the hell was a 101? What does that mean? What's a court order? And I think these are very common experiences. And I suspect that this audience is well aware of that. But I think it's really worth hearing from these people's expertise about the language, the oral language, but also the written language. And this quote was from a man who was part of a piece of work we were doing about the language and communication of protection orders. And he said the same thing that I've heard many people say, that the paperwork is just impenetrable, really confusing and hard to know where to look for the information. And yet that is often what you're supposed to understand and then be responsive to. So I think, there's so much complexity of language. And I sat in court one day when I was waiting for one of the cases I was involved in to start, and I just wrote down some phrases. And there's a reason why language needs to be complex in legal systems. There's a precision, and there's an eloquence and an elegance to that. But it's really impenetrable for many people, including me sometimes. And I'm well educated. I've got great language skills and I've got a lot of vocabulary, and yet it's very confusing to have to make sense of all of this. So I think you probably know where New Zealand is. We're just right down at the bottom corner of this map here. And we're really small, so we should be able to do this. We're only 5.3 million people, and yet we're really struggling with a lot of access to justice and participation. Our stats are grim. Māori are 17.1% of the current population, a growing population. And New Zealand is a colonised country. Aotearoa was colonised by the British, and the consequences for Māori have been absolutely appalling and go on to be absolutely appalling. And a treaty was signed, Te Tiriti o Waitangi, in 1840 between the British Crown and Māori. And that still remains. That's a fundamental part of our justice system. And how we then live that partnership, that treaty, is something that we need to grapple with as people like me, health professionals, education professionals working in these spaces, so that we actually do better than we have been doing. And I just wanted to highlight some of the relevant evidence and research that might be of interest, because Professor Tracy McIntosh is a Māori criminologist who's given a lot of evidence to the abuse in care inquiry we've had in New Zealand, but also has contributed to many inquiries, research over decades now around justice and participation, language, women, people with disabilities, and her evidence is really insightful and helpful for understanding some of the issues if you want some background. And I've also just put up the reference here for the reports that have come through the abuse in care inquiry, because it was extremely far-reaching, and they heard from evidence from many people about care and protection, but also then the ongoing consequences of people's experiences for then later involvement in other justice systems. And there's been specific reports on people with disabilities, and as well as many other groups. So again, this has been extremely helpful contextual information for somebody like me working in these spaces, because it's an extremely complex context to be working in, and then working out how do we actually be responsive. We need this understanding of this broader context. There's also been some really interesting observations made about Te Reo Māori, which is the language that really was oh, sorry, I put on a timer to remind myself when to stop, but I don't know why it's gone off now. I'm not stopping yet. So in that short video that I've put a link to here, one of our Supreme Court judges, who's a Māori judge called Justice Joe Williams, is talking about language, te reo Māori language, and the justice system, and why we're in this situation now, where actually English is the medium that most language and most court and justice takes place, and it's pretty rare for te reo Māori to be used because there aren't many speakers of te reo Māori, even though there's been a resurgence recently. So I just wanted to give you some of that contextual information, because our stats are grim. For a small country, and it's a beautiful country that should be able to get this right. We are one of the most incarcerating countries in the world. For instance, I pulled out this statistic about Indigenous women. Māori women are overrepresented, and they're 15% of the population, but 63% of the women in prison. And we lock up people, and the consequences then for people's lives are huge. So there's some really important things we need to be getting better in New Zealand when it comes to justice. So when it comes to my profession of speech language therapy, not dominated by middle-class white women like me, many of us who've come from other countries perhaps to settle in New Zealand. And there's been very few speech language therapists who are Indigenous. That's growing, which is amazing. And we need to be really supportive of that. But there's very few who are fluent in te reo Māori, although many of us are trying to learn. But also the work that's done in speech language therapy, but also in wider responses to neurodiversity, neurodivergence, and broader disability is really influenced by Western non-Indigenous models of practice, frameworks, tools, but they're not always appropriate. They're often pathologizing. And so we're needing to really shake up how we do this work. How do we make space so that our Indigenous colleagues can find the ways that they think need to be taken, and giving them opportunities to re-indigenize and then decolonize our systems. And there's some great things happening. And one of my friends and colleagues there's been some profiles of her work, because she's an Indigenous speech language therapist who's been doing a lot of postgraduate study in law, and really thinking about how do we do some of this work in the right way. And then there's those of us like me who needs to really think about how do we do our work so that we do it in the way that is best. So there's some other background here that has come out of some of the research around New Zealand. Professor Ian Lambie is one of our neuro psychologists in New Zealand, a researcher at the University of Auckland, and he's one of the advisors to the justice system and has pulled together a lot of very accessible papers that I think are very helpful for understanding our context. And then there's been some really neat pieces of work that have started to happen. So at Auckland University of Technology, there's been a very interesting piece of work called Let the Law Be Right, He Turi Kia Tika, which I've spelt the last word wrong. Sorry, I've just realized there's an error there. But that's all about mental health and alcohol and other drugs and the justice system. And it's been a very interesting piece of work where there's been people who are experts because of having lived experience of these systems, really creating the solutions, which I think is really interesting. And then there's been some work done in our justice system that Judge Walker was leading before he retired, which is about creating a universally accessible system for young adults who are going through our district court, which I think is really innovative as well. We've got courts on the Māori ceremonial meeting houses that are for Māori, and there's a similar Pacifica court, and Judge Malosi is our principal youth court judge at the moment, who is again doing some really innovative work in how do we really be responsive to the very high numbers of young people that we know are coming through our courts, and adults as well, particularly those who have neurodisabilities. So my team at Talking Trouble, we've got very strong views about who is currently in the light in the courtrooms, where they're able to communicate easily and who might be in the dark at the moment. And I guess part of our work is about how do we turn the light on? How do we make sure everybody's sitting in the light and can properly communicate? And we were really, I was explaining some of the work I do to just somebody who was doing some work at my house once, and he said to me, yeah, you'd need someone to break all that down. And I'm like, yeah, like, too right. That is exactly what we're trying to achieve, really. And there's been an initiative that I think is amazing that our work as communication assistants is kind of linked to, which is called Te Ao Marama, which our Chief District Court Judge is leading at the moment, which is really about accessible justice across cultures, across plain language, across disability. And I think he's leading some amazing work and pulling together some streams that I think is really impressive. So I guess I said I'd say who I am, but I wanted to provide some of that context first. But I've been a speech language therapist for a long time. I trained in the UK originally, and I came to New Zealand in 2002, and I've never left. And I'm here under that treaty that we talked about. So as a person of the treaty, which brings responsibilities for me. I've been working in sort of justice related spaces since about 2008. And then I was one of the first communication assistants engaged by the courts in 2015. And that's occupied my life since, really. So I'm the director of a social enterprise called Talking Trouble, and we've got around 25 speech language therapists working across New Zealand in some of this sort of work. And we do a range of roles, and I'm going to explain more about the communication assistant role in a second, but we're also very involved in training other professionals, in project work, in research, and really everything we do is to do with care and protection, justice, mental health and behaviour, but there's a lot of interlink, and it's taken us into some really interesting spaces. I'm also the lead for a piece of work called the Fair Access to Justice Knowledge Hub, which is an international collaboration of about 50 odd people from around the world interested in the application of the UN rights of persons with disabilities. And I'm the intermediary lead for that piece of work. So I guess I thought it might be quite helpful to think about what is it we're doing, whether we're doing a piece of research work, a piece of training, or I'm working with an individual. I'm really trying to think about what is this interaction this person or this thing involves, and what are the communication demands that are involved here. And then I'm thinking, what could be done beforehand, what could be done during, and what could be done after it. And I'm really thinking, what can I tweak here? Where are the levers I can pull and push? What could I introduce? And also, what could I get rid of in these kind of spaces that might make communication easier? And we've often used this sort of image. We like imagery in Talking Trouble. I think we know oral language is tricky, but sometimes being able to see is helpful, see the message. So if somebody's going through a process, has to communicate in a place, deal with people, what's that like? If it's a child giving evidence, for example, if it's a person in a family court proceeding, if it's somebody dealing with the police, forensic psychologists, family group conferences, whatever, what's going to make that communication tricky? And or is it going to be easy? And what are the demands being made on people's communication systems? And I just pulled out a few kind of things that we might be thinking about in relation to language communication and sort of functions of those. But those are often some of the things that we might be trying to think about. And for the people I work with, there's so many factors that might be impacting on communication. We might have people who have no diagnoses to multiple diagnoses. They might be developmental diagnoses or issues they've been dealing with all their lives, or they might have suddenly had an acquired communication difficulty. Pretty much every case that I'm involved with, educational disadvantage and trauma are huge. And then it's always stressful going to court or dealing with the police or dealing with lawyers, care and protection. And so mental health is often a factor just because it's stressful, but sometimes it's also an additional factor. We do a lot of work that overlaps into sort of forensic psychology, psychosis, psychiatry. But language and communication needs are often hidden in plain sight. So the professionals themselves don't always realise that there's issues. The person themselves might not always realise there's an issue either, because usually in their normal everyday life, they might be managing fine and everyone might be really good at accommodating their needs, but we put them into this much more challenging language communication, formal, high stakes situation, and it might be tricky. One person once said to me, I just need them to say the main thing and that's it. And to be honest, that is it. And I kind of often wish I could just say that to people, just do this and it will be fine. But professionals aren't good at this. They find it really tricky to just say the main thing and that's it. So I guess a lot of my work is about how do we help the workforce do that? How do we help them? And we often talk about like lending them our communication glasses. As speech language therapists, we've got these kind of well-developed glasses for seeing communication, seeing what's going on, figuring out what we might be able to tweak, often in really, hopefully, not obvious ways that don't shame and enable somebody to participate better. But we need to lend those glasses to then the workforce, and we need all the lenses on the glasses. We need the trauma-informed lenses and the lenses of disability and the lenses of the communities we're working with, so that we're seeing properly what's going on and we're not being blinded to the things that we might be missing. So I guess what we're about is trying to make sure people can participate. We are making sure that they can have a voice in what's going on and enact their rights. And there's a term here, tino rangatira, which is kind of an analogous to self-determination. So we want to get the communication pitch just right and do that tweaking. So this isn't a nice to have. There's a whole lot of work speech language therapists have been involved in around rights. I've been involved in a few of these different things. And in our country, there's legislation that speaks about right to participation. Like I've just given an example from the Orang Tamariki Act, which all the way through talks about people requiring, this is in particular children and young people, communication to occur in a manner and language that is correct, well, not correct, that's not the term they use, but appropriate for them, and support and accommodations to be provided. So we've been really thinking in our profession about rights, and we've also been quite influenced by Laura Lundy's model. I mean, I think this works really well for adults as well as children, but I think, how do we really make sure that there is effective communication and participation, and who needs to do what in these situations? So coming to the work that we are doing as communication assistants, which is known as intermediaries in other countries, we're in a broader range of spaces than in some other countries. So one of the pieces of work I've been doing for the Fair Access to Justice Knowledge Hub is really trying to pull out what is happening around the world in intermediary work. And in some countries, it's quite prescribed to a certain group, say children who are giving evidence in sexual assault or murder manslaughter cases. But in New Zealand, we're in a much broader range of spaces. We can be appointed under the Evidence Act for witnesses and then defendants in criminal matters, but also sometimes in some contexts in the family court. There isn't the same legislation that covers parole board, family group conferences and police interviews, but we are sometimes still appointed in those settings. In New Zealand at the moment, all communication assistants are speech language therapists, but we're not doing our normal type of role that you might see us in health or education in this. It's a very different sort of boundaried role that's neutral and impartial, and we need to work within the legislation and the processes that have been set out. It's been an interesting ride being involved in this work that's really developed from the bottom up in New Zealand rather than a scheme that's been created and then implemented. We've got now the quality framework that we didn't have right at the start, which is helpful, and we've started to have case law emerge, which has been looking at cases that have involved CAs and also cases which haven't, but the question has been, should they have? So it's a really interesting area of work to be in at the moment. So we're not expert witnesses when we do this work. We're not able to give opinions about fitness and capacity. We're not there to interpret or answer for the person. We're really there to have made sure that in advance we've tried to set everything up so the communication will go as smoothly as possible, and that all then needs to be agreed at a ground rules hearing before we do that work. And we're not able to express or have an opinion about anything outside of communication. That's not our role at all. We're just there about the communication for everybody. So I mentioned some of that international work, and there's now a map that we've been trying to have people from the different countries where there are intermediary schemes give information about what there is available so that people can find each other and learn about what's going on. So that might be of interest to you. But just going back to the sorts of scenarios that I might be in, it's these kind of things. It might be a lawyer needs to take instruction from a defendant. My role might be to assist ensuring that lawyer can have that communication with the defendant appropriately. It might be the person is going to be involved in a jury trial. They might be a complainant who needs to be cross-examined. They might have to participate in fitness processes and understand what's going on, and they might need to be in the youth court. I put the parole board and police interviews just with stars there because they're a little bit different, but again, the same kind of thing, like what can we be doing beforehand to get ready for this thing that's going to happen. And occasionally now we're appointed for appellants in Court of Appeal and Family Court. But the same thing we do for all really is that, and I've taken the example here of a defendant who needs to instruct their lawyer. My role is to think about what's going to be involved in that communication for this person and do a bit of an analysis of what might they need to actually participate in, what might be tricky. And then before that happens, I would be meeting with them to see what they think about that, what their views are, what the factors might be that influence. So it's not a standardized testing type of assessment. It's very functional and really trying to help work out with the person, what do you need everybody to do here? What are the accommodations that are going to work for you, and agree those with the person. So I'm thinking when I write those recommendations reports about who needs to do what, maybe I don't need to do anything. It might be that the person doesn't need anything, but it also might be that others can do what needs to be done, and there's no role for a CA to actually play in the proceedings, or there might be some roles for me to do in advance, getting everything ready with everyone. And then maybe I'm just monitoring, or I might be playing a more active role. It really just depends what the actual interaction is about and what the person needs to do, and whether it's going to be something they need to deal with in real time, or whether or not we're going to be able to deal with some of it before and then afterwards. But if I've done everything and everyone has worked with me, and I can't take that responsibility for the communication on my own, everyone needs to be playing their part there, and the interaction is successful and the person's able to participate and get what they need done. It might be also that we need to do something afterwards about what just happened, what's going to happen next, what's everyone going to do next. So that's the sort of example that we might be involved in for, say, a lawyer taking instruction. And I thought it might be useful for you to just give a few things of what we might actually be doing in that. I might be breaking down charges so that all the words make sense, and I might draw it. I mean, we've created some resources that we've often used in training here to help really other professionals think about what they can be doing. But I might create something like this to help break down, what is this charge about? Possession of instruments for conversion, what does that even mean? And the reason we put that particular charge on this card is one of the young people that one of my team was assisting once had got really, really upset in a court to the point where he was taken down to the cells, and there wasn't a communication assistant there that day. But when someone said to him, "What's the matter?" And he's like, "They're saying I did a ram raid on a music shop, and I didn't do that." And he hadn't done a ram raid on a music shop, but he'd heard instruments and he thought that's what they were talking about. And that wasn't what they were talking about. And, so we just need to make sure the professionals are really understanding this language that gets used is really confusing, and people need to understand what it is they're charged with. Or I might be breaking down a summary of facts from the police and helping to explain the time frames, the places, what actually they said, what does unlawfully uses means, what was going on there, breaking down time. I might be breaking down what other witnesses might have said, or what is in the summary of facts, so that the person can understand what they've got to decide if they agree with or they're not sure about, or what their own account is, so that their lawyer can understand. If we're going into the court, I might be helping them understand, what is this all about today? What might be happening? It's about EM bail, yes or no, basically. And then when we're in the court, I might be annotating something we've already prepared so the person knows what's going on, what just happened, and then we can go through it afterwards. bail conditions are huge for us. We've spent a lot of our lives thinking about bail conditions because this is the sort of thing that happens. Someone says, here are bail conditions. They give them a piece of paper. That is not a set of bail conditions. That's a Hungarian immigration form that's been really badly photocopied, but it might as well be the kind of information people get handed sometimes. So there's better ways to do that. So we might draw it with the person. We might have templates that have broken down the concepts so that they're actually understandable, or that people can tell us what they think their conditions are, and we've got a way to check that they actually know what they are. I might help someone make sense of time. Time is often a really confusing concept, but is really important in justice. So I'm often breaking that down for somebody to understand what's going on. I might have some tools to help people stay regulated, or to let me know if they're starting to lose it, and how then we can ask for a break, or what we might need to do in that situation, because it can be really difficult to advocate for your communication needs or your other needs in these sorts of situations. We're often involved in questioning, and there's a whole load I could talk about with the role we do when somebody needs to participate in cross-examination. But I guess the advice I'm often giving to lawyers, and when we do training for them as well, is these are the things we're often saying. Like, you can signpost the topic changes. Is it actually a question? What actually are you wanting to ask? And can we help you ask that in a way that is likely to be understood by this person, so they can give their own answer? Get rid of all the complex vocabulary. So we might help the lawyers break down questions. Like, I remember a lawyer once saying to me, I need to ask her if she frequently absconded from school during term 4. And you just go, well, could you ask, did you go to school every day? So there's just ways of breaking down language so that it's a better fit for the person. Using visuals if they're appropriate and not going to be leading. There's a whole can of worms there, and just figuring out how to just help lawyers just think about how to actually ask questions that people might be able to make sense of, particularly if they've got particular reasons why language and communication might be hard for them. So I'm going back now to all of those experiences we've had working in these systems mean that we're often being asked in to do projects or training. Like, we've got a big piece of work going on with our youth justice workforce at the moment. And so we're just trying to figure out, what can we help other people to do? Because it's not realistic always for there to be a communication assistant available. We know not everyone has one who maybe would benefit from it. And maybe it would be great if we weren't even needed, because everyone was actually communicating in a way that actually worked for everyone. So we've kind of worked out a few things that we think are helpful. We've sort of decided we've got this bit of kit that we like to implant in people's brains called a blarometer. And so then it will go off really loudly when they hear the blah coming out of their own mouths, or when they see it written down or hear it coming out of other people's mouths, and they know how to turn off the blah, and they know how to do it more easily. So some of the ways we've done that is we've got some simple tips and tricks that we basically help people think about and explore with us about how could they doodle with purpose in the work they do? How do they check understanding rather than just tell people stuff? How do they break things down? How do they really think about what might be going on behind the behavior that they're seeing on the surface? And some of the project work we've been involved in has been really interesting. Like, I was involved in some work to do with DNA, which is an extremely complex topic, that people have to make decisions about whether to participate in DNA testing or not. We've done some work in prisons trying to help people think about the staff, think about how complex is the language people need to understand when they come in. Could it be done better? Are there better ways of explaining information or having resources that actually work better for people? Are there ways people could do their assessments or consult people that actually are giving people space and time to communicate, and utilizing strategies like talking mats? And we became a bit obsessed by talking mats and became talking mats trainers. And so this has been some work we've been doing with some psychologists who work in our corrections, inside the wire and outside the wire. And also we're doing a piece of work in forensic mental health, forensic secure hospital at the moment, really thinking with the staff about the conversations they need to have and how could they do those differently when actually just normal talking is not working very well for people. And talking mats is another tool that we've been thinking about in that. Other ways people could have agency themselves and say, this is how I need it to be, this is what I need people to do. And could people create communication passports or other sorts of passports that actually help people to have their say about what they need people to do for accommodation? We've been thinking about virtual communication and been, especially during COVID, this became important for individuals to participate in court online, in meetings, in high stakes contexts, but communicating virtually is tricky. I mean, it's amazing that I can talk to you right now from New Zealand at night when some of you are waking up in the morning, but it's tricky for a lot of individuals. So how do we think about what could be tweaked in that situation? So we've come up with a few different resources that we share. I've put all of those on there. And there's so much more to do. We're not even touching the sides of addressing communication really in the justice system, but we're having a good go. We should be able to do this. New Zealand's not that big, but there's many unresolved issues. So doing this in a way that honours Te Tiriti o Waitangi, I think, is really challenging. And there's a lot of work to be done there. There's been lots of discussion and debate about fitness to stand trial and conceptually where do CAs fit into that and who decides who does need a CA, who doesn't need a CA, how do we tell, who tells whether it's actually working or not? There's much more that needs to be done. There's a lot more research that needs to be done. And I guess I'm coming back to that kind of timeline I wrote at the beginning. I feel frustrated as a speech language therapist that I often get to meet somebody for this tiny little opportunity, and then other people involved, including the person themselves, might say, so can you carry on, because this has been good? And often there's nothing before that maybe would have prevented this person from ending up in this situation in the first place, whether they're a complainant, whether they're involved in the family court, in the criminal courts, and then afterwards, where are the responses? Where are our speech therapists and other professionals working on some of this stuff in a much more rigorous way afterwards? So there's lots to do, but we're encouraged. We're working with some amazing judges, lawyers, police, social workers, researchers, psychologists, psychiatrists, and participants. And one of them is an amazing judge who's retiring this year, and he has set up the court that's the homeless court in Auckland, where I live, and he's also been involved in the crossover court, trying to really pull together children who have care and protection needs and youth justice needs and work out how do we do that work much better. And Judge Fitzgerald has been really involved in really trying to work out how do we communicate better with children, young people, adults, families who are coming through these systems. And he had this quote, which I'm going to finish with. It was not until CAs became involved in cases that I started to understand how language difficulties impact on young people who come before the youth court. That has led me to rethink how I communicate with all young people I meet in court and see an urgent need to change the language forms and processes we use to make them more capable of being properly understood. This must go beyond simply removing the anachronisms in institutional language. New, fresh, and meaningful approaches are required. And I agree with him. So I'll leave it there. I put some resources on and you can have the slides and there's some links, but I'll stop sharing and there might be some questions you have for me or some comments. Yeah.
Thank you, Sally. Thank you so much. That was wonderful.